Hi guys, my name is Olga Donchenko. I'm a seasoned agent with Berenbaum Homes. I'd like to welcome you back to my YouTube channel. I'm excited to introduce my new guest, Mariya Berenbaum with MBLAW.
Hello.
To tell you a little bit about Mariya, she was called to the bar in 2011, and since then your career took off. You now run your own practice. Why don't you tell me a little bit about what your journey has been like?
In 2011, I was called to the bar and I decided very early on that I wanted to focus on real estate. Real estate was my passion. And I decided that real estate was going to be my happy law, right? So that was my niche. Really wanted to see people happy rather than, unhappy. So people come in, they get their keys, they're very excited. So I kind of live off those happy molecules. And it helps, it helps. I feel like
And you
doing
truly,
good.
exactly, you truly get to be part of that journey to that happy place, right?
Absolutely.
Like, I've had the pleasure of working with you on multiple deals. My clients are absolutely in love with the process and communication. So that's for sure has been a great component that they highlight always with working with you. And today I'm happy that you're going to share your wisdom with us.
Sure.
Why don't we start off with you walking us through the typical closing process?
So some of the areas of law, you could kind of fumble, but real estate is not kind of one of them. So you can't really do it yourself. So luckily, only a real estate lawyer could help you with the closing process. And it's very complicated if,
You do it yourself.
you do it yourself. Obviously, you cannot. But it's really complicated to begin with. So you really need somebody who knows what they're doing, who has an experience. And especially in today's market, there's all these things that are popping up last minute. So somebody who practices and, somebody who knows what they're doing would know how to deal with the issues that can pop up on the last minute. With respect to the closing process, it's really, I'd like to say it's really simple. We get the agreement of purchase and sale, we review it, we make sure that, all the conditions have been satisfied. We see if there's anything extraordinary that needs to be done on the closing process. We pull title, we look at the property, we do the searches on title and off title searches, and then we discuss it with the client. Really, at the end of the day, it will depend what the client wants to do with the property and what is the client's goal with the property. And then, as everybody says, then it's just paperwork, right? So,
And there's a lot of it.
and there's a lot of it, exactly. Then we, get the mortgage instructions, follow the mortgage instructions and what they need us to do, meet with the client, sign documents. The clients bring in money for closing, for example, for purchase. And on the final day, we convey title. So sounds very easy. But in between, there's lots of intricacies that can go wrong, and also lots of intricacies that we just have to follow, lots of steps that we have to follow to make sure that it's done correctly.
For sure. At what point in the purchase, let's call it the purchasing process, would you say it's important for the buyer to call their lawyer? A lot of the time, maybe it's also different between pre-construction and resale, because a lot of the time I find, for example, my clients, they will wait until all of the conditions are waived and the agreement is firm, and then they take it to their lawyer, even if I will tell them, hey, why don't you review this with your lawyer in the meantime? And then what I find myself challenged with is then the lawyer could come back with certain comments that should be reflected in the agreement, but we are now firm, so it's extremely difficult to go back to the seller.
Right. So I agree with you. So I think it also depends on the client, right? And whether or not they're willing to do the work and whether the lawyer is willing to do the work. So I love seeing agreements before they're firm because again, like you said, even if you deviate a little bit from the standard clause, you need to have the extra set of eyes from the legal perspective to protect your interests. We had so many times where the deal was falling apart and the agreement was firm already, and the client comes to me and says, well, do something about this. And I said, well, I can't do anything about it because my hands are tied, because the clause is drafted in such a way where, an example, they had to repair something and they didn't repair. Ask for a holdback. guess what? The holdback was not written into the agreement.
Right.
Or, holdback was written into the agreement, but the amount was not agreed upon. So now, rather than having a smooth closing transaction, we're arguing with the seller's agent or the seller's lawyer as to the amount of the holdback.
Right.
So, like I said, I love seeing agreements before they go firm. It doesn't cost you anything extra to have a lawyer to look at the agreement and make the necessary changes. And long term, you're saving money because the more work that we do outside of the general scope of the retainer, the more we're going to charge you for it. So rather take that extra step, have the agreement reviewed before it's firm. It's going to save you time. It's going to eliminate the stress, and it's going to save you money in the long term.
For sure. And similarly for the sellers.
Similarly for the sellers. Yeah. Absolutely. Absolutely.
Because sometimes the purchaser may put in a clause. It reads well. Everybody, this is situations I've been in. Everybody seems to understand exactly the meaning behind the clause, but then the seller's lawyer reviews it. And from a legal standpoint, they're just a sentence or a few words that need to be altered just to make sure that the meaning is really clear and there's no vagueness to it. So I found situations even in the seller side where it benefited them to have a lawyer review something just to make sure those, as you said, those custom, we call them custom clauses, not the standard ones, the ones maybe the buyer's agent put together,
right,
are protecting both parties in this regard.
Absolutely. And in terms of the pre-construction agreement, so you have 10 days to have it reviewed. Don't wait until day 9. Just don't do it, everybody's busy. Everybody has busy lives and busy practices. And, you're also not doing yourself a favor by waiting until day 9 because the lawyer is going to rush through the agreement. And the agreement is sometimes, 40, 50, 60 pages.
Yep.
Your lawyer could be the fastest reader in the world, but they still have to take time and do their due diligence and going through the agreement and also taking the time to review it with you. Because let's face it, when you get a DocuSign link, nobody's reading it. Everybody's just clicking through it. So
especially when it's 40 pages.
Especially when it's 40 pages.
They look at the numbers and the names and the closing date.
Absolutely.
That's all.
Absolutely. They do look at that.
Yeah.
And then when it comes to pre-construction, a lot of people say, oh, are the adjustments capped? This is the most important thing for me because I need the adjustments to be capped. So adjustments are just extra costs, right, that you pay to the builder on closing.
Yep.
It could be development charges. It could be park levies. It could be, utility connections. Yes, that's important. I'm not saying it's not important. It's important. But also other clauses such as assignment. Are you allowed to do an assignment? Are you allowed to add your spouse or your parents or your family member onto the agreement? Because let's face it, in today's, again, economy, when it's time to get the mortgage, sometimes you don't qualify just as a sole owner of the property. Does the builder allow that? Does the builder allow renting during occupancy if you're not occupying the unit? So these little things that, you may not know about could really impact your, purchase. And also the other thing to think about is what happens if you want to get out of the agreement, right? Yeah. It's a contract. It's a valid contract. It's a firm contract. But today we're seeing, people that bought at the peak of the market. Obviously, the economic landscape has changed.
For sure, yeah.
It's time to close. They may not be able to close, but the agreement is worded in such a way, again, where they cannot get out of it. Or, they can't close for whatever reason. They don't have an assignment clause. So they don't even, their hands are now tied. Mm-hmm. And then they can't assign the unit, even though they found a person who is willing to purchase it, even at a loss.
Right.
And some people do sell it at a loss just to kind of eliminate that liability with the builder rather than not closing.
And some builders would put in, from my experience, they would put in a fee associated with the assignment.
Absolutely.
So you also need to be aware that there is. And I mean, for my practice, and maybe some other realtors, if they want, can take the advice. I tell my clients, don't just flip over the agreement to your lawyer. Do a summary of things we discussed and we said these are the things that we did agree, such as we do get an assignment, a free assignment clause, or we get an assignment clause at a discount. We have like put it in a summary so your lawyer knows that they're not just reviewing a standard agreement, but they also need to look for those items that you've negotiated to be reflected. Because I've had situations where they would come back to me and said, well, how come these are not reflected? I'm like, well, did you make sure when you were sending the legal document to advise your lawyer that these need to be reflected?
The other issue is when you're adding a spouse onto the agreement of purchase and sale, the builder will treat it as an assignment.
Yep, they will.
So that's number one. And a lot of the clauses now are drafted in such a way with the builder that on assignment, you lose all the benefits of the caps that the builder was giving to the original purchaser.
Right.
So guess what? Your development charges that were capped at $10,000 are now no longer capped, right? So you have this new issue of uncertainty. So on one hand, you're adding your spouse to qualify for a mortgage. On the other hand, all of a sudden, you're losing all the incentives that the builder was giving you at the beginning of the contract. So it's very important to take a look at it. So not just say, okay, yes, there's an assignment. Yes, we could do it. But does the assignment trigger anything else?
Yeah. And make sure you reflect exclusions such as spouse or family member being added to title for sure.
Well, sometimes they could say, okay, let's assign it. Let's add the spouse to title. And all of a sudden we need to assign again. Yeah. Right? So
I've had those instances as well where essentially it's just one-time assignment.
Yeah.
And then that's it. You've ended up losing your assignment clause and now you have to pay a fee or there's other implications to it.
Exactly.
Can we talk a little bit more about the situation where a purchaser bought pre-construction, higher prices, the market, I would say common situation to people who bought pre-construction 3-5 years ago. They need to close today. The market has corrected. They are no longer able to qualify for the mortgage, or for example, the valuation of the unit is no longer at the price they're committed to in the contract. Their question is, how do I get out of the agreement? And do I get out of the agreement? What would you say in that situation?
Well, I think first of all, it's very complicated and it's very situation specific. Right? So everybody will have different financial situations. Everybody will have different financial goals. So really it's a case by case basis. But at the end of the day, if you don't want to default, don't default, right? So, and even if you have to be able to kind of look at your financial situation and what is your financial goal? Are you buying it for yourself? Right? So then you would make different financial decisions versus if you were buying it as an investment property. So if you were buying it for yourself and, for example, the market corrected and all of a sudden the appraisal came in, let's say $100,000 less, do you have savings
that will cover
the difference? Or the market, same situation, the market corrected, you still have like $100,000 shortfall. Do you have the finances if it's an investment property, right? Does it still, do you have the faith that the market is gonna, correct back and you're gonna make your money and you're gonna get the $100,000 back, right? Is the renting market healthy? Do you wanna deal with it? So lots of things that you have to think about before you make that decision. At the end of the day, you also have to say, okay, if I do default, what is kind of the safest way for me to do it to limit my exposure of damages, right? So if you know, and again, this is in no shape or form coaching people how to default, right? Yeah. So if you know that you're going to default, if you know that you're not kind of exhausted all possible avenues, and I as a lawyer will always say, you have to close. Figure out how you can close and let's work together with the builder to see if we could do something to help you close.
Right.
But if kind of all options were exhausted and, you are not able to close at the end of the day, like, some situations are like that. People just, don't have the money and don't have the means, and they just walking away from, hundreds of thousands of dollars as their deposit under the agreement of purchase and sale. And in that way, we could reach out to the builder and say, okay, how could we limit the amount of damages? And that is basically a mutual release. Hey, builder, my client is unable to close. Keep the deposit, but let's sign the mutual release. So essentially your damages are limited to your deposit.
Right.
So rather than losing, $100,000 and then being left open to liability that now the builder is selling the property for $300,000 less, and the builder will come back and recoup those losses from you, you're only losing $100,000. And I say only $100,000.
It's still a big amount.
It's a huge amount, right? But $100,000 or $400,000, I'll pick $100,000 any day of the week.
For sure. So you kind of answered my question. So I was going to, so a lot of the people, they're in a situation like this. They call me up and they're like, well, I'm just going to walk away from the deal. I'm just not going to close. Let them have the deposit. And that's that. I guess the question I would have had is like, well, it's not just that. Does it end at that? I think you just answered it. It doesn't, because you keep yourself absolutely open if you just walk away from the deposit, even if, yes, you're giving them your 150,000, because then they can sue you for the difference if they end up selling the unit less. So I guess the situation that arises is, how do you come to that agreement? Do you tell the client to go to their agent, or is this really a legal question?
Well, I think it depends. It depends whether or not it's a pre-construction or if it's a resale, right? So with the pre-construction, really, we're mostly dealing with the builder and the builder's lawyer. So the builder's really, there's no, I don't want to say it's not a person, because obviously it is a person,
right?
But it's an entity. They're selling thousands of units, so it's really hard to have that one-on-one conversation and sit down and say, listen, like, my client is going through some really tough financial times. What can we do where both parties, I want to say both parties are unhappy, right? Because this is kind of like, at the end of the day, kind of, this is what you want to do.
Minimize losses for both.
For both, right? So like, I understand that you can sue. I understand that you could do all these things and you can enforce the contract. But you as an individual, for example, in the resale, it's going to take you time. It's going to take money. It's going to take, lawyer fees for you to go and recoup that. And what people don't understand also is that you could go to court and you could get a judgment saying you now owe me $400,000, right? So let's say the losses were $400,000. Yep. The worst part about it is the enforcement. Where are you getting that money from, right? So if a person doesn't own any other real estate, it's going to take you a really long time to garnish their wages to get $400,000.
For sure.
So you also have to think about, okay, so yes, I'm suing, but what do I have? What does the person have? The buyer have? How am I recouping my losses? So, and with the builder, it's a well-oiled machine. They have the template. Everybody goes to court. They get it. They will get enforced. How are they getting enforced? It doesn't matter, because guess what? Like, it's just a well-oiled machine.
Yep.
So don't do it. Don't default. But also, you have to, on default, you have to minimize your damages. And that's kind of like one of the things that you, as, a buyer that defaults, that's your responsibility. Because when you go to court, the judge is going to say, well, what did you do to minimize it?
Yeah.
And then all of a sudden, guess what? I own the property and I have a line of credit, but it's at, 8%. And I technically could have pulled out, the $400,000 or whatever the shortfall was, but I didn't, because the interest rate on the line of credit is higher than the mortgage. So the court is going to look at it and say, well, you could have closed.
You chose not
You
to.
chose not to.
Yeah.
And so based on that, we have obviously the enforcement procedures.
Right. For sure.
Yeah.
Well, switching our conversation into a little bit of maybe more of a positive note.
Right.
There definitely are a lot of challenges in today's market. Can you share a happy story where your legal advice helped a client in a certain situation?
Oh boy.
I'm sure there's lots.
There's lots. There's lots. So actually, happy story that came out almost from like a nightmare story. We had a seller client who bought a property, not with me. It was a very custom property, very big lot, beautiful custom home, beautiful pool, beautiful cabana. They bought with a different lawyer. He came to me to sell. Downsizing, everything like picture perfect. He's happy, buyers are happy. And then I get the requisitions as a seller's lawyer, and there is a building permit. And the building permit was not, checked by the lawyer that was purchasing. By the way, for the record, you don't have to check it. Mm-hmm. Again, you can follow your client's instructions and basically say, these are the on-title and off-title searches that I could do. Which ones would you like me to conduct? After reviewing the deal, I would recommend conducting A, B, C, and D.
Right.
So again, maybe the lawyer said, let's do this. The client said, I don't want to spend any money because guess what? Everything costs money. I don't want to search. Let's just close as is. Again, I wasn't there. I cannot comment on it. But the terrible thing that had happened was that the client's, the work order basically said that the cabana was built incorrectly. And we're not talking about a shed here. We're talking about a property that was sold for over $10 million. So the cabana,
a couple $100,000 for sure.
Yes, for sure. Right. So all of a sudden, the foundation was done incorrectly. So the buyer would essentially have to tear down the cabana and rebuild it in order to fix the work permit, or tear it down and not rebuild it. And then obviously that way the work order would be closed. But here's my client who did not build the property, is dealing with this a week before closing. Right. So it's extremely stressful situation. Thankfully, who came to the rescue? Title insurance. Mm-hmm. So title insurance stepped in. We called title insurance. We explained the situation. We pulled the old agreement of purchase and sale to make sure that, there wasn't anything there to indicate that,
they were
aware of it. Exactly. We spoke extensively to title insurance, and title insurance essentially went in and covered the losses. So, amazing. Yeah. So really it was up to, and again, we were acting for the seller client. So title insurance was purchased at the time when he was purchasing the property, and it saved his butt essentially on the time of closing. And we were able to transfer title insurance to the buyer and have a comfort letter for the buyer saying, by the way, if you choose to remedy this situation, title insurance will step in and deal with the work order. Again, whether or not the buyers did fix it or they continued to live with, the open permit on the property is up to them, because obviously, in order for you to fix it, you have to first spend the money to remedy, and then you'll get reimbursed by title insurance. But nonetheless, knowing when to step in and knowing kind of like what avenues and what remedies you could suggest to your clients,
right,
to be able to do it. And I think that's kind of like the job of a real estate lawyer.
For sure. And it also, the extensive experience comes in, because I feel like with the real estate transactions, it's never the same thing. No. As I said, maybe with like pre-construction, it's an oiled machine, because it just seems all of them are all very similar or like typical in the transaction. Right. With the resale, you're dealing with a case-by-case situation, and right. You have to be knowledgeable, you have to have the experience, and you have to have, I call it creativity, to think outside for creative solutions to a problems, not just be like, no, this is the agreement, you can't get this done.
Absolutely. And I think a lot of the times we get like bad rep. as lawyers and they say, well, my real estate lawyer said this and that we cannot get this done. And sometimes it's true. Like sometimes we just, we can't get anything done because, again, like you said, the agreement is drafted in such a way that it's limiting the things that we can do. But the only thing that, like our job is to advise the clients of the consequences, right? Our job is not to make the decisions for the clients. For sure. Our job is just literally say, okay, this is what the agreement says. This is the consequences if you don't do this, and A, B, and C could happen. So you let me know. We could take avenue A and we could do this. Avenue B, we could do this. Avenue C. Oh, but what should I do? And I said, well, I can't tell you what to do because, I'm not the one that's going to be dealing with the consequences. But I will tell you that if you go here, this is what most likely going to happen. So make that decision. But the most important thing is like to make an informed decision. So don't just like throw it at clients and say, well, the agreement is firm. There's nothing I could do about it. Go talk to your agent.
Yeah.
Right. So I'm sure, and this is kind of something that I wanted to kind of bring up with you, that there's this, I want to say like almost like a division wall
like
between
a disconnect, right?
Correct. Between like a real estate agent and a real estate lawyer, where we're like pointing fingers, right? And saying like, oh, hey, by the way, the realtor forgot to include this in the agreement. Go deal with the realtor. And then the realtor will say, well, this is actually a legal issue. Go deal with the real estate lawyer.
Yeah.
Which creates a problem for the client. Because at the end of the day, if we keep pointing fingers, like we're not working together.
Nothing gets done.
Nothing gets done. It's like, well, you know what? Like I'll run in my lane. You don't get your nose into legal issues. And I'm not going to kind of like put my nose into like the real estate issues because, you're the expert there and I'm the expert here. So let's run separately on adjacent lanes and never talk. And I think at the end of the day, like the client loses.
For sure.
So this attitude of disconnect really shouldn't be there. So I find that working together with a realtor from the beginning is how you create a successful real estate transaction. It could be purchase, it could be sale, but working together, because at the end of the day, everybody wants to close.
I couldn't agree more with you. Same thing. This is why so early on, I tell my clients, connect with your lawyer. I will actually reach out myself and have a conversation. If it's a new lawyer that they choose to use, I will introduce myself and tell them like, hey, we're dealing on this. Let me know if you need my assistance in any way. As you said, the best way to achieve, after all, we're after the same goal. We want to service our client and get the transaction closed. So it's essential, I should say, not just important. It's essential to be in communication, to be on the same page. And a lot of the time, I don't know why I feel like a lot of agents are afraid to call the lawyer. I will tell them, like, my colleagues, I'm like, let's just call the lawyer. You're not sure. Yes, this is the clause. This is how I would draft it, but let's just call the lawyer. Does the seller or the buyer have a lawyer? Call them up and tell them like, hey, my client, your client essentially as well, my buyer client, for example, wants this reflected in the agreement. This is how I'm thinking of structuring this clause. Do you have any input? It's one phone call.
Yeah. And that one phone call can really solve so many headaches, right?
Exactly.
So being proactive. And a lot of the times also, we don't have the lawyers, right? So like, I'm sure you're dealing with this all the time. You'll have, your buyer who's ready with a lawyer.
Yes.
And then, or let's say you're representing the buyer. And then you have the vendor, the seller, who doesn't have a lawyer, right? So who's like, oh, we haven't decided yet. And we have that issue all the time where I need to send a letter of requisition to the seller's lawyer. And there's like none to be had, right? So like I'm sending it to the brokerage.
I've had to deal with that too, where essentially my client's lawyer, like we were securing information for the lawyer an hour before the title search date was up.
This is insane, right? Like,
I mean,
why
it
is this still
happened,
happening? No,
but
for
it
sure.
was so much stress. It was like probably 12 hours of just being on the phone and calling the brokerage, the broker, the agent, like everybody on the phone just to secure lawyer information.
Right. And you're not doing yourself a service as a seller who doesn't have a lawyer at that point of the transaction. You have a firm agreement, find a lawyer. I mean, you could throw a stone and you could find a lawyer, right?
Yeah.
So just Google, if you don't know how to find one, Google, look at the Google reviews, see what's convenient for you, see how many years of experience they have. Are they practicing real estate? Are they practicing 10 different types of law? Like just, are they good at real estate if they're practicing 10?
But ask your agent.
Ask your agent.
Your agent
right?
does this.
Right.
Your agent does this on a daily basis. I'm sure.
Right.
Like, I mean, for us, we just send an email, just be like, hey, you just purchased a property. These are your next steps. If you need referrals, let us know. Or here are 3 lawyers or 5 lawyers that our clients worked with in the past and we had great reviews. And they can call them up and choose.
That's perfect. Yeah.
Like it's not hard for sure. I feel like a lot of the time, this is why I was asking you, like, walk us through the closing process, because I feel like a lot of the time, especially with first-time buyers, they're not aware at like what are the next steps, at which point. Like, so I feel like, as you're saying, sometimes this disconnect is because maybe the realtor doesn't know at which point they need to stop guiding their clients.
Right.
They stop guiding their client at the moment the agreement gets signed. But really, there's so much work and so much communication that continues.
I think you hit the nail on the head where you said, at what point do you stop guiding your client? And to me, I think when the client picks up the keys.
Yeah.
Right. So, and especially if it's a first time home buyer, like, I don't know if you remember your first closing. I remember my first. Oh my goodness, I was so nervous. And I mean, I come from this background, but I was so nervous signing papers, figuring out what is happening.
And overwhelmed.
It was so overwhelming. And at the end of the day, like, I was so stressed out and I knew the steps that needed to be taken. So imagine somebody who is a first-time home buyer, who is buying the property, right? Already, like the biggest investment in your life, and who doesn't have that guidance. So I think finding a person or finding a realtor who is communicating, and I always say, like, I'd rather have somebody who's extensively communicating with me. Like, send me 20 emails, ask me crazy questions, ask me all kinds of questions, even if they're not like something that I could help with. They'll say, oh, hey, do I need to have insurance? I'm buying a condo. I have my friend who's telling me I don't need it. I have my mom who's telling me I need it. I have my boss who's telling me I have insurance through condo. Like, what do I do? Why are you Googling? Yeah, right.
Get the insurance.
Get the insurance. Like, why are you wasting your time? And again, like, sure, do your due diligence, Google, whatever. But also, like, what is your time worth, right? Contact a professional, contact your real estate agent, contact your lawyer and say, hey, I don't know if I need the condo insurance. Yeah. Do I need it? Rather than spending 2 hours Googling if you need it. It's
or
one
asking
email.
Everybody else.
Right.
And to talk about that sense of feeling overwhelmed during a transaction, I feel like your realtor is that trusted source that can just tell you, yes, this is normal. Yes, you are doing the steps that need to be done. Like, this is normal. Everyone goes through this process, because they get overwhelmed. They're like, am I the only? I get this from first-time homebuyers. Like, am I the only one signing 100 pages? No, you're not. You're getting a mortgage, so you're signing all this. But I already went to the bank and signed the mortgage there. I understand. This is the package you need to sign with your lawyer. They will walk you through it. You need this to get the mortgage registered on title. Like, they just need that reassurance from somebody who's in the industry. Because as you said, there's always cousins, brothers, sisters, and friends and neighbors. That's my favorite one.
Oh, my neighbor. Yeah. My neighbor never paid land transfer tax in my life. I'm like,
my favorite is like, my neighbor never got title insurance, which is another thing I wanted to get back to. My neighbor never got title insurance, and they've been living in the house for 40 years. Everything is fine.
I mean, it's possible. You've been living in the house for 40 years. 40 years ago, title insurance was not a thing.
Yeah.
Sure, maybe they don't have title insurance. But again, now, going back to the story of title insurance, saved $400,000.
Yep.
Or title insurance with fraud. Now there's so much fraud, so much title fraud. Title insurance will step in and deal with it. So really, you're paying for the price of the title insurance is really minimal considering the benefits that you're getting.
Yep.
And everybody's going to tell you like, oh, it happens to them. It would never happen to me.
Yep.
I'm proactive. I do this. I check. Nobody's going to do it, right? So really, you're buying title insurance. It's a one-time cost. It covers you until the end of your ownership. Sure, you will be able to, again, if you stay with the same bank until you sell the property, you won't need to buy title insurance again. You will have to buy title insurance again if, for example, you're switching lenders. So obviously a new lender would need to be covered. But in terms of your own homeowner policy, you pay just once, and the benefits that you reap from it are astronomical, right? So
For sure. It's a minimal, I don't even call it an expense. It's a minimal investment into a peace of mind. And down the road, if there's an issue, kind of, it's an insurance against you having to pay anything out of pocket.
Absolutely. And there's obviously ways to not buy title insurance, right? So the lawyer could say, hey, title insurance is not mandatory. You don't have to do it. You don't have to buy it. You could just do all the necessary searches to ensure that you're getting clean title. So we would do, tax search, you would do the utility search, you would have to get a survey to make sure that there's no encroachment issues. So a brand new survey is going to cost you $4,500 to $5,000. Okay, great, we got that. We saved some money on the survey. So title insurance, let's say it ranges, right? So it could be $500 to, up. So on the property, let's say that's $1 million, you're looking at about $900,000 for title insurance. And again, lots of factors can influence the premium, but at the end of the day, let's say it's $1 for $1. And it's not, it's a little bit less. But you're saving on a survey, which is $4,500, right? And
So your 900 for title
Right.
covers you not just with things that are reflected on the survey.
Absolutely. And the other thing is that I could search until the cows come home, but all my searches are going to tell you that up until this moment, the title is clean. But once you close, you have no protection against fraud, which happens after the transaction is done.
Yep.
So really, it's just not worth it. And as a matter of fact, it's almost like an industry standard now. If I have a client that comes to me and says, hey, by the way, I'm buying a property, I don't want title insurance. It's a huge red flag. So to me, when a client comes and says, I don't want to buy title insurance, I say, you know what, I'm not going to work with you.
It will be a challenge trying to sell this property and then having to deal with something if it comes up.
Well, I mean, for sure, right? So let's say we buy it without title insurance. And again, I don't know many lawyers who would act on the transaction without title insurance. But let's say somebody did.
Yep.
If issue comes up, it's going to cost you an arm and a leg to deal with it on the sale.
Yep.
And once somebody told me, judge all your purchases by your sales. So if you did your purchase correctly, nothing is going to go wrong from the title standpoint, of course, on your sale.
Yep. I always tell my clients whenever they are like, oh, you've been like, they're like, you are a different agent. You don't just tell us like, yeah, go for it. You actually tell us issues with properties and like, you actually tell us not to go for something and go for something else. They're like, why is that? I always joke with them, like, because at the end of the day, you're going to come back to me to sell it.
Yeah.
And as you said, judge your sales by your purchases, because yes, our clients, they get excited. They see a beautiful property. Everything seems to be done, but we have to look past, the beauty, the sparkle. We have to see and make sure that does the layout work? Like from a standpoint of an agent, does the layout work? Does the location work? Is this renovation that they're going to be paying a premium for going to last them and in the future resell and bring them, a positive return and things like that? And yeah, it's very interesting that you say that, because that's what I experience with my clients. And then when they do sell, they're like, we're so happy you told us to go for this one instead of that other one that we were so excited about, because we saw it go on the market and they haven't been able to sell.
Well, there you go, right? So like, again, going back to your comment of somebody who has a lot of knowledge, so the expertise, they know the market, they know the area, and they know the type of property. And also, I know you come from, like a construction background as well. So you also know the potential, what you can achieve through renovations.
Yeah.
And through adding things to the property to maximize your return. So you're not just looking for a property for a client that, the client will say, well, I want this type of property. You're also looking at it from, another perspective where you say, okay, yes, but also like we could add this, or you could do this, or here, if you renovate here, you will maximize your money. Or this is the up and coming neighborhood where you will get your money back.
Yeah.
And again, you're doing a service for your client, because at the end of the day, both you and I are in the service industry. Everybody can, draft an agreement of purchase and sale. How they say, oh, the agent is just drafting the agreement of purchase and sale.
Or the door opener.
Yeah, or they're just there opening doors. And no, sure, we're not saying that there aren't agents out there who are not doing it. Sure, there's just agents there who are drafting the agreement and opening doors. Yes, but how do you stand out in an ocean of these agents?
Yeah.
And it's all through service. What is the benefit that the client is getting working with you?
For sure.
Right? You have your knowledge, you have your experience, you have your builder background. You bring all of that to the table to maximize the return on their investment.
For sure.
Same thing that I would do, right? So they come to me and I always say, well, I'll bring my like doom and gloom of like, what could possibly go wrong? And I look at the deal comes to me, and the first thing that I say is, everything is going to go wrong on this deal. Will this agreement work?
Yep.
And the answer is yes, I'm happy with it. Or the agreement is like, no, are we still, in the conditional period where we can make some adjustments? Are we firm? Okay, how can we prepare for
the worst
case scenario? And I'm like the worst case scenario girl. Because
Yeah.
I'm like, okay, things are going to go wrong, because let's face it, sometimes they do. And I want to prepare the client, and I want them to anticipate the solution.
Yes.
Right. So I want to prepare them and say, okay, so this is what it says in your agreement of purchase and sale. The seller has to, for example, make repairs.
Yep.
Guess what? Holdback was not noted. The time of repairs was not stated, that they have to be done before closing, right? So now, like, when is the timeline? When are they doing these repairs? When you move in? Maybe. When you move out? I don't know. There's nothing in the agreement to say that they have to be done before closing. And again, this is something that could have been avoided with, like you said, one phone call to the lawyer.
For sure. I could also say that I feel like network is another benefit that a seasoned lawyer or a seasoned agent can bring to their client. Because some situations we can be maybe not equipped, or, for example, like, if there is an issue that something needs to be repaired, for example, let's talk repair, right? In my regard, it's like, well, I can't, even though I have a background, I had experience, like, doing renovations and things like that, but I'm not licensed in that regard. I would outsource them and be like, hey, let's take the extra step. I'm like, I'm not sure. Maybe the property lines haven't been, held. Let's do the survey. Like, I can come to them and be like, hey, you're buying this property because you want to develop on it. Do the survey. Make sure you protect yourself by doing it, right? So, and you can connect them like, hey, here's a surveyor. Here's like another professional. If there's an environmental issue, for example, here's another professional. So I feel like it's also network that you're bringing to your clients.
Absolutely. And like you said, like network is also very important. And while spending the money on a survey, short term might be painful, right? Yeah. Long term, you're avoiding issues. And if you're looking at a couple of properties, I'm not saying like go out there and like survey the city.
Yeah.
I'm just saying speak to the surveyor, speak to the professionals, speak to the network of people. Because, this is what we're doing. We're bringing people that will help you to maximize the dollars,
They're investing. Yeah.
Exactly.
For sure.
Exactly. And I always say, like, whatever problem there is, it could all the problems with real estate, obviously not the world's problems,
Yeah.
all the problems in real estate can be solved with two things. It's time and it's money,
Yeah.
right? So it's either you losing your time trying to fix it, or you're paying somebody the money, be it, reducing the purchase price or being like you're losing on your investment. But again, you're in a sense solving it that way.
Yeah. Anything new you've been seeing that you had to deal with in today's market?
Yes. So one of the most interesting cases actually that just popped up a couple of months ago was a sale of a property. Again, I was acting for the vendor of a property in Toronto that had a laneway house. So to deal with the shortfall of possible dwellings where people can live, Toronto allowed
Laneway suites.
laneway
right?
suites to be built if you have obviously a laneway. So you could build a separate house at the back of the yard or on the side of the yard, depending on the layout of your property, to create additional essentially space to live. And it could be an in-law suite. It could be a place that you rent out for somebody to bring extra income to yourself for the property. It could solve lots of issues. But the issue that came out from the legal standpoint is the development charges agreement. So and again, things now have changed. So Toronto, I think at this point, has passed a bill saying that you no longer have to pay development charges if you are developing a laneway house on your property. And again, do double check if that is actually correct. It might have changed recently, but for this particular case, at the time when my client has started developing a laneway suite, development charges did have to be paid to the city.
Those are hefty charges from what I know in the city of Toronto.
Correct. So this particular house, they had to pay $60,000 in development charges, which is a lot of money.
It is.
Right? So you're trying to maximize, again, your investment. You're trying to see, okay, so I'm building this suite. I'm going to rent it out. What's the rental income that they're going to bring? How much value is it going to add to my property? Because let's face it, you're not building a $100,000 shed in the backyard.
No.
You're spending $200,000-$300,000 to build something decent, that will add the value to your property. And, there's lots of companies that build laneway suites, and it's a great solution to the shortage of housing. But there's problems with it. So he did the laneway suite, he built it, and the city of Toronto said, hey, sign this agreement. It's called Development Charges Deferral Agreement. And if you don't sever your property, and if you don't try to separate the laneway suite from your main property, in 20 years, you do not owe us anything. Sounds like a dream.
Right.
It isn't. It turned out to be a complete nightmare because, number one, the development charges deferral agreement was registered on title as a restriction. So that should have been kind of notified. The buyer should have been notified that they're taking on this development charges agreement. Right. The development charges agreement was drafted in a very confusing way. And it basically said that every year that passes from when you built it until year 20, the development charges get annexed annually. And how I read it and how the vendor's lawyer read it is basically year 10 you owe us half, year 20 you owe us zero.
Yeah.
No.
Okay.
That is not what it turned out to be. So basically, long story short, the buyers decided, we don't want this. We didn't know about this. We don't want anything. We don't want this cloud to be on title. At the end of the day, we want clean title.
Right.
So then the client basically had an option of walking away, saying, fine, let's sign a mutual release. You go look for something else, and I put the property back on the market. And that would have been a great solution if we were in the hot market where he could resell the property, disclose the development charges agreement, and move on with his life. But his property was on the market already for 6 months, right? So now he's saying, okay, what are my losses? In his mind, it's an extra $30,000. Forget it. It's been 10 years. I owe them 30 grand.
Yeah.
Let me just pay it and move on. So we start talking to the city and say, hey, can you send us, what you owe? And the city sends out the bill for $90,000. And we say, well, what?
So that's 30 on top of the 60?
So that's 30 on top of the city. And I said, well, what is happening here? Like it says in the agreement, in the deferral agreement, that it will be annexed. And they said, yes, well, I mean, I know what it says, but what we really meant is that it's going to be assessed at the current annual development charges rate. So if on year 19, you decide to sell the property and the current development charges rate is so much higher than it was when you built 19 years ago, we will say, well, today you would have paid $100,000 to develop this property. So please pay us $100,000 to get the development charges agreement out.
Crazy.
Which is insane, because had my client known that that's what it was, they wouldn't have deferred.
For sure.
Or maybe they would have disclosed. I mean, there's lots of maybes.
And just for clarity, this is selling the property as a whole. So the
Correct.
main house and the laneway suite.
Correct.
So he never actually went through severing it. It's not like he was selling the laneway suite separately from the property where like the severance would have been done, because now there's going to be two people on two different titles.
Correct. So
This
he
is
was
still as a
selling it
whole.
as a bundle. Correct. He was selling it as a whole, and the buyers, you couldn't even sever it because really the utilities are attached to the main house.
sure, yeah,
I mean,
yeah.
it's a mess to sever it.
Yeah.
But the city said, okay, like if you don't sever it, year 20, basically what we're going to do is
Charge
you zero. So year 20, the development charges rate is zero. So you're paying zero, which was, neither here nor there because we were selling on year 10.
Yeah.
And
So what happened in the end?
at
How
the
did you sold that?
the client ended up paying $90,000
Wow.
to get rid of this development charges agreement. And again, had he had a lawyer review this agreement and maybe reach out to the city and have this explanation and say, hey, what does this mean? Annexed every year, does that mean that on year 10 I owe half of it? And had they told them, no, on year 10, you would owe whatever you owe at the year 10 development charges rate, maybe he would have made a different decision. Maybe he would have said, you know what, I'm not going to defer. I'm going to pay now because I would rather pay today and not deal with it in the future. Or another thing is, maybe I'm not going to pay, but when it comes time to sell, I have to disclose it to the buyer and I had to, let them know that they're going to take that on.
Yeah.
And I think that's one of the other things that, I don't want to point fingers here, but one of the other things that a seasoned agent would have said, oh, you have a laneway suite. Did you pay the development charges?
Yeah. Do you have anything?
Do you have
charged
anything
to the title? Because
Correct.
we as realtors don't get to see anything on title. So
No.
half the time we don't know whether our clients still owe. Like sometimes our clients are selling at a loss, and their mortgage charged on the property could be higher than what they're selling, and we don't even know that. This is a whole other story.
It's a whole other story.
But I mean,
Absolutely.
like, exactly, we need to sometimes be able. So, and honestly, being a seasoned agent, until you and I had that chat on the phone, I wasn't even aware that this challenge could arise, because me, even being like relatively knowledgeable in the whole like development sphere of things that is touching real estate, I wasn't even aware that that charge wouldn't just be mandatory to be paid. I didn't even know there was an option to be deferred. Right? Because when you're developing something else, you don't have that option to defer.
Right.
You just pay it when you're, like, let's say a client severed one big lot into two, they just pay the development charge.
Right.
It's just one of those things where you don't know until you're hit with a problem.
know. Right. Right. So you learn from the mistakes, right?
Yeah.
So, and it's not even a mistake, really. Like nobody has made a mistake.
Yeah.
It was all about disclosure and asking the right questions, right? So, you have a laneway suite. Did you pay the development charges? As a client, as a seller, saying, I mean, very few people would come out and say, oh, by the way, 10 years ago, I've signed this development charge agreement
To defer.
to defer my charges. Is it important?
And
I
then we
don't
s-
know.
well-
As
well,
a seller, like
yeah.
with no background, like maybe it's important. It definitely is important, but like, how do we know, like, where is this development charge? Is it registered on title? If it was registered 10 years ago, you know, maybe the seller forgot. Maybe the seller didn't know.
Yeah.
I mean, no, for sure the seller knew.
Well, if they
because
signed, they would have known.
Right. But then, like, do you remember what you signed 10 years
Yeah.
ago to disclose it at the time of the sale to your agent and obviously to the buyer?
Yeah.
So a lot of things went wrong on that deal, and it cost the client a lot of money. So really, how can we have avoided it? Pull
Seems
title.
like you handled it in the best way.
We did,
Like-
and really, the buyers were willing to walk away, and we had extensive conversations. We had extensive conversation on mutual release. So really, the buyers would have taken their deposit back. They didn't want to have any extra money. They didn't want to be paid out for, you know, inconvenience of now looking for another property. They didn't want to be paid for a rental because guess what? They came out of the rental. They gave notice. They're now living in Airbnb because the property was closing mid-month. So they didn't want any extra money. They just wanted out. They wanted out of the deal or they wanted the agreement off title. So again, going back where I disclosed to my client, okay, so option A is you give them the money and we sign a mutual release. You put the property back on the market, you relist it, you disclose the agreement, and we take it from there. Option B, you pay the deferral agreement, we register the discharge of the
And you
deferral
close.
agreement, and then you close.
Yeah.
So it's really, you know, everybody has a different financial situation. What do you do?
Yeah.
And the client made the decision to pay it out and close.
I always say key is whenever you have a problem that you're bringing to your client is to have options.
Yes.
Not just leave them with the problem, but rather have options. Even if neither of the options are perfect, but having those options for them to decide on.
Absolutely.
Yeah.
And they weren't perfect, right? Like one option, it cost a client $90,000. The other option, we don't know how long it would have
been more
taken.
costly.
Right. We don't know how long it would have taken him to sell the property. Maybe a day, maybe a month, maybe 6 months.
Maybe
right?
a year and then
We don't know, right? So like you said, giving the client options, even if they're not that great, but you know, giving them an opportunity to make an informed decision.
For sure. Well, thank you for coming on. I love the chat. I honestly feel like our time just flew by, and it's always a pleasure speaking with you. As I said, I had the pleasure of working with Mariya and her team on multiple occasions. Everything was amazing every time. You're very resourceful. You're extremely knowledgeable. I know there's a lot of deals coming our way in the future. Real estate seems to be getting a little more active. I know.
Fingers crossed.
And on my end, as always, it's been Olga Donchenko with Remax Berry Cohen Homes. And if you guys liked this episode, there'll be more interesting ones to come. So like and subscribe. Thanks. Bye.